Thank you very much, and greetings from my humble study in my home in Singapore. As we've heard the Chief Justice in his opening remarks point out, the pandemic has changed our lives, disrupted us greatly, not just our personal lives, but also in the world of commerce. So it gives me great pleasure to be moderating this panel session with very distinguished speakers. We have, first of all, who will be addressing us by a video recording because he's unable to join us online live, Mr. Sean Wilken, Queen's Counsel of Keating Chambers. And I wouldn't be doing justice to all the illustrious CVs of the panelists, but I just want to highlight one or two things of each of them in the CVs. Mr. Sean Wilken has dealt with the legal ramifications of disease outbreaks, toxic spills, terrorist incidents, and international lockdowns. And so that's extremely relevant to this panel discussion. Our second presenter will be Justice Doug Jones, AO, and he's an international judge of the SICC, and he has 40 years of prior experience as an international transactional and disputes project lawyer, which allows him to give us extremely valuable insights in this session as well. Our third presenter and speaker will be Sir Vivian Ramsey, who studied engineering, science, and economics at Oxford, and it has an interesting mix between engineering and law. So he's previously an English High Court judge and a judge in charge of the Technology and Construction Court. So we are in for a very interesting panel discussion as well as a Q&A session afterwards. But let me just preface the session, the presentations, with a couple of context-setting remarks. As the Chief Justice has pointed out, infrastructure is a huge area of interest, especially in this part of the world, in Asia, in ASEAN. The ASEAN community has obviously a pipeline of infrastructure projects in mind, and this has been disrupted by the COVID-19 pandemic, no doubt, changes in cost structures, delays and closures, and so on. Similarly, the program that's proposed by China in 2013 called the Belt and Road Initiative has infrastructure as one of its main focus areas and has generated a great deal of economic activity and interest. So out of these initiatives and infrastructure and commercial transactions, we can expect the pandemic to generate a number of disputes or a rethinking of how we handle contractual negotiations and provisions, which might have to, in the coming years, deal with post-COVID-19 situations or issues. So without further ado, let me turn over the time then to the recording that's been kindly provided by Mr. Sean Wilken, who will take us through some of the most salient features of something that's come up, which is on force majeure clauses and related issues.
Good morning. I am here to talk to you about infrastructure and COVID-19, or SARS-CoV-2. One starts with the question of why does it matter? Well, in part it does, because I'm appearing virtually in this talk. I'm somewhere in the very far north of Scotland as opposed to being in Singapore. That's because obviously I can't get to Singapore. I can't leave, in fact, Scotland. And that is one of the impacts of the pandemic. Why does it matter to us as lawyers? Well, obviously there will be disputes. There will be disputes over international supply chains. There will be disputes over cross-border issues. There will be domestic disruption, disputes over that. So within the UK, some people talk about an 80% drop in productivity in the economy as a whole. Some others talk about 20%. Either way that you cut it, that is significant. As this pandemic continues, obviously we will see greater and more severe risks of insolvency. And of course we will have repeated lockdowns which will affect all of the above. There's also a wider long-term issue here, which is the extent to which the pandemic will change the paradigm of how we operate as international lawyers or as international dispute resolvers. This talk is going to come in 3 sections. First, I'm going to talk about what we have learned. Then I'm going to talk about the law as it relates to force majeure. And then I'm going to talk about sectoral impact. I have prepared a note. I'm not doing slides, but the note should be available, so you won't need to be taking a verbatim note of cases as I refer to them. So what have we learned? We have learned that there have been globally very different reactions to the pandemic. We have what I would call the laissez-faire populist model, UK, US, Brazil, Sweden. We have what I call the pulse model, which is repeated, strictly enforced lockdowns. That's France and Spain. And then we have rigorous isolation, track and trace, which is pretty much the Pacific model, New Zealand, South Korea, Japan, Singapore. We've also had differing legal reactions. In China, almost immediately, the government of the PRC issued force majeure certificates to all affected industries. At the other end of the spectrum, we have in the UK extensive use of non-binding guidance, or in the US, devolution from the state, the federal level, down to the individual state level. We have also learned that the position changes over time. In other words, I am giving this talk on the 16th of February at 09:12 GMT. I make that point because by the time you hear this talk, things will have inevitably changed. This means as lawyers dealing with the issues that arise, we both have to ascertain the position as it now is and as it was before we begin to talk about how that might impact in terms of claims, force majeure, and so on. Now, turning purely parochially to England, the position has been very confusing. And I'm not the only person who thinks this. Tom Hickman, who's a Silk at Blackstone Chambers, has written a paper on it about how confusing and difficult the position legislatively has been to unpack. This has also been made more difficult because we actually can't recreate what happened when it happened without using Wayback Machines. In terms of global claims, however, the thing that we're going to have to construct in every case is what I call the COVID timeline. What happened when and how it's relevant to the dispute that you're talking about. What have we learned in terms of legal lessons? Well, obviously we have the different nations adopting different regulatory approaches. But more precisely in terms of force majeure, obviously we have the distinction between the civil law and the common law. The courts of civil law nations have more freedom to find a case-appropriate outcome because they have an established doctrine of force majeure. And again, as we're talking about Belt and Road in the Pacific, and indeed infrastructure in the Pacific, one can have a look at what happened in the PRC. Historically, SARS was regarded, the original SARS, as a force majeure event, but again, pretty early on, the government of the PRC, via the Ministry of Housing and Urban-Rural Development, made a statement that SARS-CoV-2 was force majeure, and that was February 2020. Returning to the common law, here we are tied to the words of the contract, and there is no established doctrine of force majeure. So if one looks at Chitty, paragraph 15-152, it is a contractual term by which one or both the parties is entitled to cancel the contract or is excused from performance of the contract in whole or in part, or is entitled to suspend performance or to claim an extension time for performance upon happening of a specified event or events beyond his control. And then one goes back to Le Beaupin in 1920, and of course there is a historical synergy in that 1920 was the year of the Great Flu epidemic, and we are now 100 years later, or 101 years later. Le Beaupin says, this term, namely force majeure, is used with reference to all circumstances independent of the will of man and which is not in his power to control. Thus war, inundations and epidemic are cases of force majeure. However, later, one has in Thomas Borthwick the precise meaning of this term, if it has one, has eluded lawyers for years. So force majeure in the common law tradition is an inherently uncertain term. But we do know there are certain things that someone invoking force majeure must prove. The event, effect on performance, due to circumstances beyond their control, no reasonable steps to be taken to avoid it, all necessary notices given, and that's tangent and aero. So looking at the event, our standard contract wordings are perhaps unhelpful. The JCT gives you time, probably not money. FIDIC has a multiple step process to establishing force majeure, and of course FIDIC is important because a lot of contracts coming out of the PRC are FIDIC. The NEC, anything that stops or delays completion, so the NEC oddly here has a better wording. Turning to the energy sphere, the AIPN Joint Operating Agreement says that force majeure mirrors the upstream contract, so of course you're straight into local law issues. Logic for the North Sea, force majeure includes change of law. Beach for the export of gas, you must prevent the supply of gas. And then the Hong Kong GCC allows a permissible EOT only. But you again can contrast here the PRC. You can see Article 180 of the General Provision of the Civil Law and Clause 17 of the Standard Form both allow for an epidemic-based force majeure event. Note, some help may be there in your underlying financial documents if you have a material adverse change provision, but the wordings may not be helpful. So one turns to the authority both old and new. One has Le Beaupin. Epidemics fall within the confines of force majeure where the term is not expressly defined by the contract. Tangerine and aero. A force majeure clause was engaged where a seller of aircraft was unable to deliver due to a pandemic. Interestingly, in Atwell and Rochester, a builder who became ill was discharged from future performance due to the relationship of trust that the builder had with the client. And then one can go back to some very, very old law from the time of bubonic plague in the 17th century, Lawrence and Twentyman. If a man covenant to build a house before such day, and then the plague is there before the day, and continues there till after the day, this excuses him from breach of the covenant for not doing it before the day, for the law does not wish to compel him to venture his life for this, but he must do it afterwards. So there are some statements in the general law that help. Looking at specific wording, again we're in the common law. Hinder versus prevent. Prevent means performance must be legally or physically impossible, not just more difficult or unprofitable. And that's pretty close to the test in Article 180 of the PRC General Provisions. Inevitably, insurmountability is there. We know that prevent means prevent because the UK Supreme Court has considered it recently in the case of the FCA and Arch, where they considered prevent in the context of COVID and said, well, prevent does mean prevent, but a statement of directive will from government, even if not incorporated into law, might suffice. Hinder, perhaps you will be doing better on a hinder wording because that includes dislocation of business, but does not include, however, merely more expensive performance. One then has the hurdles, again in the common law of causation, see drill, and notice. Both of these are significant hurdles. So in the common law, one has a difficult position of trying to get within the clause. However, in other jurisdictions, you have a more freestanding concept where you are not tied to the wordings and you have greater flexibilities. Now, these differences between the civil law and the common law are manifestly important in and of themselves, but they also are very important when you are dealing with international disputes, as we all inevitably are. I want to take some examples. And this is the third section of my talk, which is sectoral impacts. I want to start with supply chains. Now, anyone who wants to go back and look at lectures that I did at the beginning of COVID, almost a year ago now, as far as England and Wales is concerned, I was very much a supply chain skeptic. I said it is very unlikely that you'll be able to maintain a force majeure claim for supply chains. Today I am less so, and the reason for that is the pulse effect of the pandemic. It comes in waves. So what you have is repeated attacks on the supply chain. And that has both an individual and a cumulative effect, because of course cumulatively obtaining alternate supplies may become difficult. You also have the aspect in the supply chain that your supply chain may embrace both civil and common law countries. So there will be an engagement with how force majeure operates differently in each of those. And then in supply chains, one again can look to some old law, though this is the 1970s as opposed to the 1670s, the Mississippi flood cases, which concerned the impact of a force majeure event on supply chains, on cargoes afloat. These are difficult cases. I raise them because they are there and they could be important, but I'm afraid in the time allowed, I don't have time to go into their very complicated facts. Next sectoral risk is insolvency and capital risk. What we have seen are central banks changing their capital adequacy regulations in different ways in different countries, and we've also seen an impact on state aids. Infrastructure. The key theme that others will be picking up on in greater detail and with more erudition than I possess. But infrastructure, I can see three impacts. One is liquidity and access to funds becoming tight. Two is differential localized impact. And three, cross-border differential regimes back to the civil and the common law. As far as we as lawyers are concerned, I want to raise two themes that the pandemic has created. The first is the challenge. Is this the new normal? As we move to technology, 18 months ago, this talk, namely virtually done via these various platforms, would have seemed to be difficult. E-bundles were there, but were thought to be novel. Is this going to impact things like cross-examination? How are we going to adapt our processes to ascertaining truth in the virtual context? Does this mean that arbitral hearings will become less adversarial? Is there also an opportunity here? Does the pandemic mean we can save costs? You no longer have to fly your counsel and arbitral teams around the world. And of course you have seamless and rapid access 24/7. But I would express some skepticism here, because preparation for e-hearings takes much longer and may cost more. Finally, however, a possibility of a new future is, I think, the pandemic has triggered a change, or could trigger a change in diversity. Those are my 15 minutes. Thank you very much for listening, and thank you for your time.
Thank you, Mr. Wilken. Next, may we invite Justice Douglas Jones, please.
It's a great pleasure indeed to be part of this symposium. I'm intending to address, in the context of the massive infrastructure needs of the region mentioned by the Chief Justice, the context of the Belt and Road contribution to that need. And in particular, I would like to look at aspects of arrangements within the Belt and Road projects which extend beyond the traditional construction contracts, which are, of course, a very important part of the building of infrastructure. And it's in the context of these other agreements, necessarily part of the Belt and Road Initiative, that the contribution potentially of the Singapore International Commercial Court can be considered. In order for a Belt and Road project to be brought to fruition, there is usually a need for financing. And that can be by means of traditional overseas development aid agreements or more commercially oriented, sometimes multilateral financing arrangements, which are necessary in order to fund the initial construction and perhaps continue to fund the operation and successful implementation of the projects. The potential issues which can emerge from those funding agreements are, of course, closely related to the success of the construction activity itself and to the commercial viability of the project going forward. And the potential issues which can emerge if projects fail to achieve the objectives considered at first to be those sought to be implemented can be considerable. Secondly, the facilitation of Belt and Road projects often requires an engagement between governments and the private sector, where a private sector entity, sometimes in the Belt and Road context, a government-owned enterprise, will take a long-term concession for the operation of a project, such as a port, an airport, a power station, or a road. These concession agreements are obviously implemented to allow the entities who run these projects after completion of construction so that they can successfully reap the financial rewards associated with revenue which arises from the projects. Tolls on roads, operating costs charged to users of ports, the sale of power coming from power generation projects. And those concession agreements can be either with one national entity in the country in which the project is being conducted, or perhaps in a context where there are regional governments as partners in the project, agreements between national governments and regional governments, municipal or state. Now, those concession agreements are an essential part of the legal structure of such projects. And indeed, the expectations which are fulfilled or not, as the case might be, of the project will often be argued out and presented for commercial success or otherwise within the context of the concession agreements. We have, of course, already heard significant discussion about ISDS, and many of you will be well aware that it's in the context of concession agreements that there are a significant number of investor-state disputes extant in the world. The context of how those disputes might be resolved is a very specific one in the context of concession agreements. Those concession agreements are also simple contractual arrangements between the operator, investor, private sector party, or state-owned enterprise, and the relevant governments. And the resolution of issues under the concession agreement may be quite independent of the exercise of investor-state rights associated with some other investment treaty. For projects to succeed, many of them massive, there will need to be project facilitation agreements entered into between perhaps governments, but certainly between the host government where the project is being implemented, and those who are constructing and then operating the project. Often, those agreements are necessary for the facilitation of environmental approvals, for planning approvals, for the capacity to import and export material associated with the construction and operation of the project, and indeed in relation to the actual carrying out of the construction work, establishing, for instance, standards of construction, safety, and obviously environmental standards which are associated with the actual construction and the operation of the projects. Now, those project facilitation agreements are state agreements, but are very important commercially for the implementing parties who are building and then operating the project. Finally, I would like to mention, in addition to the construction contracts, long-term operating and supply agreements, which will be necessary for the viability of the projects. You might take as an example a power project where the fuel for the project, be it LNG or coal or perhaps fuel oil, will be necessary in order to ensure its commercial viability and indeed for the purpose of assessing that viability in the first instance. Long-term operating and supply agreements. For instance, by way of example, in addition to resources necessary to fuel a project, such as a power station, might be the exploitation of particular mineral or other resources, which are then sold outside the country where the project is being carried out, and the viability of that project will depend upon long-term contracts for the sale of the product. LNG projects are an example where the LNG is on-sold to consumers around the world, and the viability of that project will depend upon long-term contracts put in place for the sale of the product. So within long-term operating and supply agreements, there needs to be a capacity for flexibility in relation to changed circumstances, not just COVID-19, but changing market circumstances over time. And a mechanism in those contracts for adjustment in the event of alterations in price or the need for review of compensation over time, just as a normal function of the market. Now, those examples of agreements, in addition to the traditional construction contracts, illustrate a very significant need for effective dispute resolution. In many of these contracts, more than one party is involved, and many of these contracts sit within a matrix of other contracts, which raises very acutely the issue the Chief Justice raised at the outset of more than one party being interested in the outcome of a dispute and the limitations of arbitration, which of course can only provide a resolution of the issues between the parties to the arbitration agreement. So it's in the context of the need for independent, very detailed and indeed expert adjudication of disputes that we are looking at the potential contribution of the SICC to that process. Many of the issues which emerge in the Belt and Road context will also pick up the need identified by the Chief Justice in his opening address of a capacity for there to be a means of resolution of the issues short of hard-edged adjudication. Negotiation and mediation are an essential part of that, And being able to see that in the context of the offering available in Singapore is a very important part of evaluating how parties might in the first instance choose a dispute resolution mechanism in these contracts, or, importantly, decide after issues have emerged upon an appropriate forum for the resolution of those issues. And it's in that context, moving forward in the Belt and Road initiative, that it is suggested that a very significant contribution in terms of neutrality, expertise, and holistic dispute resolution can be provided by the SICC. Thank you.
Thank you, Justice Jones. Next, may we invite Justice Sir Vivian Ramsey, please.
Thank you. I'm delighted to be able to join this symposium and this session of it on an early morning in a cold spring here just outside London. I'm going to concentrate on three topics which I brought together some of the topics we've already heard, and those are relating to dispute settlement, and in particular Belt and Road Initiative disputes and how those are dealt with under standard forms of resolution, and some pointers to how they might be dealt with by international commercial courts. I'm also going to look at multi-tiered dispute settlement clauses, and those, of course, have already been touched on by the Chief Justice and just now by Professor Jones. Then there are some particular issues on Belt and Road projects relating to the role of state-owned enterprises, SOEs, in those projects. So let me start by looking at BRI-related disputes and how they're dealt with under standard dispute resolution provisions. Those disputes cover the usual category of infrastructure disputes, delay, disruption, termination, quality, and such matters. And as we know, the pandemic has had quite a large effect on most worldwide construction and infrastructure projects. In particular, it's affected the site. There have been lockdowns which have prevented the site from being worked on. There have been delays to supply chains, and those are particularly hard where supplies are assembled in one country from components in another country, in particular electrical and instrumentation projects. And then there's labour. The inability of labour to work for the hours they thought they were going to work for, and that has brought inefficiency. And as Sean Wilken so excellently described, these have led to a whole gamut of possible suspension and impossibility claims coming out of them. Now, how are those traditionally dealt with? Well, of course, it depends, in the first place, on what dispute resolution clause has been included in the contract. And in many, there's an embedded standard form of dispute resolution, very often the FIDIC form, with an ICC arbitration clause. There can be a drafting lawyer's preference, which means it's more bespoke, and sometimes there's a client preference. Clients may favour a particular place or a particular form of dispute resolution. And then finally, very often one finds that from the main contract or from a financing contract, the dispute resolution provisions are stepped down into all of the lower tiers of contracts on a project. It's often said that these dispute resolution clauses are midnight oil clauses, because often negotiating the whole of the contract, suddenly somebody gets to one of the final clauses and there's no proper analysis of the options. Now, overwhelmingly, in the past, disputes on BRI-related projects have been dealt with by international arbitration, and that choice has come about because a domestic court is unattractive. In other words, a Chinese party is unlikely to want to go to the domestic court in the country where the project is being performed, and the organization in the country where the project is being performed is unlikely to go to the Chinese courts. And therefore, international arbitration has allowed a choice of place and law and rules to be made by the parties, and in that way to give the parties an equal say in the way in which matters are dealt with. Decision on the proper law is very often a neutral law, and in context, for instance, of the Pacific Rim, very often that leads to Singaporean law. Equally, a decision on the place of arbitration, and again, that very often leads to a neutral venue, which is very often in this region, Singapore. Then there has to be a decision on the institution. Is it going to be one of the large international institutions? Is it going to be just an UNCITRAL, or is it going to be just an ad hoc arbitration agreement? And sometimes, as one knows, there are agreements where no choice is made. That can be either because the clause is so ambiguous that it can't be determined, and in those circumstances, the dispute very often leads to a domestic court dispute in the place where the project is being carried out. Sometimes it's possible to get out of that particular jurisdiction by relying on a bilateral or multilateral investment treaty and then have an investor-state dispute. Experience of BRI contractors in the past has been usefully set out in some research, which has been included in a book on the Belt and Road Initiative. And that has highlighted the difficulty, which I think one appreciates in the Pacific Rim generally, of people getting on with the project, not complying with the requirements of the project as to notice and other things, but deciding to complete the project and then resolve the dispute after that. And that has led to a number of difficulties of non-compliance with the contractual provisions. However, I think the development is that now, particularly Chinese parties have become much more open in their understanding and experience of dealing with disputes, very often under a common law framework, under a FIDIC contract. There have been specialist arbitration institutions jointly agreed between Chinese authorities, and for instance, in Africa, there is KJAC, which has rules and centers in Johannesburg, Shanghai, Beijing, Shenzhen, and Nairobi. There are also, of course, international courts, and the Chinese International Commercial Court is now in being, and I understand has had a number of cases, but I think it's accepted generally that those are likely to be cases where a Chinese party has a dispute with another Chinese party. And then, of course, within the Belt and Road Initiative, a choice of the Singapore International Commercial Court, where we've heard about the neutral venue and the law which is often chosen in any case, and where particularly there is a panel of specialist judges who deal with infrastructure cases. And so I think looking forward to developments, I think international commercial courts will become a more popular choice for BRI-related disputes. Let me now touch on multi-tiered dispute settlement clauses. The intention is to have some form of ADR before you go to litigation or arbitration. The main reason being not wanting to spend the time and cost of a full dispute if you can resolve it by an alternative process. And now I think one can say that most major disputes have some form of ADR before they hit the main hearing in litigation or arbitration. Bespoke or embedded clauses can have one of a number of alternatives. There's negotiations between senior managers. There is a dispute avoidance process where issues are sent to a neutral before they arise as disputes. There's mediation or conciliation. There is a decision by an engineer, an architect, or a commercial manager. There's a decision by a dispute board. And all of those decisions can be binding, or binding if not disputed, temporally binding or non-binding. And the compliance with the multi-tiered dispute resolution clause can be a requirement, which means that you cannot go to litigation or arbitration unless you've complied with it. And I think one can see that there's a whole gamut of possibilities which allow for a particular form of dispute to be properly dealt with by either a dispute avoidance or some sort of intervention by a mediator or conciliator, or some form of decision by a person or a dispute board so that it seeks to resolve the dispute without going further. And then finally, my final topic is to look at state-owned enterprises in BRI-related infrastructure disputes. As one knows, these combine public authorities and commercial entities, and of course are playing an increasingly important role in investment internationally as part of the Belt and Road initiative by China. They often raise issues such as authority within the SOE, compliance with the laws and regulations governing the SOE, such questions of whether the rate of return on a project was good enough, and the performance of commercial contracts. Now, a particular issue which has arisen is the way in which under bilateral investment treaties, an SOE is treated. Are they a national of another contracting state, so that they have the rights under the bilateral investment treaties, or are they not? And two cases, the Beijing Urban Construction Group and Yemen, and what's known as the CBQ case, because there were three Chinese parties, and Mongolia, illustrate that the tribunals are very willing to accept that SOEs, in fact, are performing a commercial role, if that is the conclusion they come to on the facts of the particular case. In the case of the Beijing Urban Construction Group, where they were constructing an airport in the Yemen, the tribunal looked particularly at the way in which the SOE was set up, but said that that was only part of the picture, and that what they had to look at was really the commercial activity. There was an open tender, they were bidding, there was bidding as contractors in competition, and particularly the alleged termination in that case had arisen because of a failing to carry out the commercial purposes. And so in that circumstance, the tribunal was able to come to the view that the SOE was really a national of a contracting state, China, and was a commercial entity undertaking commercial activities and therefore covered by the BIT. To summarise, I think the traditional routes to deal with BRI disputes are now subject to change, particularly with international commercial courts. I think there's an importance in looking at dispute resolution, in saving time and costs by using ADR. And finally, I think that SOEs have to look very carefully at the way they operate to ensure that they come within the commercial field rather than, as it's said, being an agent of the government or discharging essentially government functions. Thank you very much.
Thank you very much for those extremely enlightening and thought-provoking presentations. We've got a lot of material to think about. We have some questions coming up in the audience participation. Before I share one or two of the questions, just to put it in perspective, because Mr. Sean Wilken, QC, is not with us online, I'm very grateful to Honourable Justice Douglas Jones and Honourable Justice Sir Vivian Ramsey for being very sporting and willing to take the questions on behalf of Mr. Wilken. So therefore, the first couple of questions actually do relate a little bit to part of Mr. Wilken's presentation in his recording, and it relates to the question of litigation costs. Because Mr. Wilken did mention in his presentation that the use of e-bundles is growing, the use of Zoom in litigation, and so on. So the questions are related. The two questions, I'll read them out, and then I will invite both of you to comment. The first question is as follows. Do remote hearings save costs for cross-border international infrastructure and commercial disputes where voluminous documents and technical issues which require experts are common? And the second question, it contains a greeting from Justice Gerhard Walbank from the British Virgin Island Commercial Court. And Justice Walbank's question related to costs is as follows. Are you seeing a reduction in litigants' costs with counsel attending hearings by Zoom, etc., rather than traveling to court? And he comments, no reduction here. So may I invite first maybe Justice Jones to comment, followed by Justice Ramsey. Thank you.
Well, it's certainly the case that infrastructure disputes generate a lot of documents. Many of them now, of course, are not physical, they're electronic. So the process of absorbing and dealing with massive electronic databases, which are said to be relevant to disputes, is with us whether we are working in a virtual world or whether we are having in-person hearings. I think going forward, it would be fair to say that there is not, from the pandemic-related processes that we've followed, a reduction in the need for efficient analysis of the data that's associated with projects. It has remained a constant, I think. How it has been deployed for the purpose of hearings has, of course, varied. But going forward, I think there is a challenge in arbitration and in litigation to ensure that the material which is deployed by parties is both proportionate and material. There is always an instinct by those who argue cases not to avoid any potential contribution to success, and focusing the work of parties on what actually matters is a challenge for courts and for arbitrators going forward, pandemic or otherwise.
Justice Ramsey.
Well, I think one has to focus on where costs are spent in litigation or arbitration. And of course, what has changed is really that remote hearings, hearing component of litigation or arbitration is now taking place remotely. Therefore, you don't avoid all the costs leading up to the hearing, which in many cases are the vast proportion of the costs. Equally, you don't reduce the number of people involved in the hearing. You normally have the same number of people in the hearing. I don't think in modern case management that the hearings now take a large amount of time. Traditionally, in common law litigation, they lasted months. Now they last days or a couple of weeks, probably at most. And in those circumstances, the costs of the hearing are small, and all that you save in terms of costs is some airfares and hotels and so on, which frankly is very small by comparison to the rest of it. In terms of dealing with expert evidence and complex cases, I have found in the past few years that most of the work has actually been in preparation for a hearing, reading the experts' reports, reading the witness statements and the core documents. And I find that there is no disadvantage in remote hearings. So going back to the final point, I think any reduction in litigant costs because of remote hearings is minuscule.
Thank you very much. I'm moving along to the next question, and it contains greetings from Kuala Lumpur from Justice Lim Chong Fong. And the question is as follows. How can multiple connected parties be compelled to litigate in the SICC if they do not consent to be included? Would either of you like to take up this question?
I'm happy to take the stand. The position clearly is that two parties will go to the Singapore International Commercial Court. As any court, a court can join parties, and that court therefore is able to join parties, perhaps a subcontractor, perhaps a supplier, perhaps some other party in a typical infrastructure project. And once the court has done that, then the jurisdiction of that court over that party is obviously a question which may be debated, but that party becomes a part of that litigation, and therefore the court can deal with that party. And as one knows from experience, where parties are joined in litigation domestically, parties comply with the orders of the court and come before the court in the vast majority of cases. So I don't see a problem of joining parties as one can under the joinder rules.
In fact, if I understood the earlier presentations correctly, this is in fact one of the interesting features of the SICC. So thank you very much for that. Just to check, Justice Jones, did you want to add anything to that last question?
Nothing to add.
Okay. We're moving along in time. I am conscious that we have maybe about 5 more minutes. We have 2 questions left. And the next question relates to parties using dispute systems, what the attitudes might be, and perhaps we can get your observations. The question is as follows. Are parties more inclined to take a different view of how their disputes may be resolved following COVID-19? For example, the opportunity to resolve disputes at international commercial courts because of the flexibility and availability of international judges. I think some of this was already touched on in the Chief Justice's remarks and other speakers' presentations, but just to invite the 2 justices here to give any additional observations that you may wish to share.
I think it's a little bit early to make judgments about that. I think the disputes emerging from the pandemic are yet to be, in the majority, crystallised. But I do think that it is really important to try to ensure that there be a maximized opportunity for parties to resolve those issues by negotiation, if possible. Therefore, the comment made by the Chief Justice in his opening is a really important one. The capacity to combine hard-edged adjudication with means of amicable resolution is really important. And I think in the context, particularly of the ISDS debate, which was raised in the previous session, the capacity to have COVID issues which emerge from countries seeking to protect their citizens resolved by negotiation rather than ISDS formal processes is really important. So the opportunity in Singapore for that to occur is a really important one in my view.
Thank you. I think that underscores the point of the need to address the needs of users of dispute resolution systems who are out there. I'm sorry, Justice Ramsey, you wanted to add something.
Well, I was just going to say that one of the things which I think everybody would agree is there are a lot of uncertain issues coming out of the COVID crisis. Those are uncertain issues in the interpretation of standard forms of contract. They are uncertain issues in dealing with the sort of claims which come out of either suspension or impossibility and so on. And touching on a point which was mentioned in the first session, of course, if everything goes to arbitration, the outcome of those individual disputes doesn't lead to any learning. And the learning which you get in a court by having a number of judgments which deal with those sorts of points means that people become aware of what the outcome may well be in their dispute. And therefore, I think there is a particular point coming out of COVID where people want certainty or knowledge of how a court would interpret certain facts against certain terms of contracts, which lead to the great importance of using a court process such as those in the international commercial courts.
Thank you very much. And that, I guess, relates also to the fact that you can access easily judgments of international commercial courts and read the reasoning and glean from such judgments whatever lessons might be learned from these interpretative exercises, and therefore try to reduce the uncertainty that you mentioned, Justice Ramsey. We have one last question, and I know we're running very close to the time. With your indulgence, I would just like to raise this last question because it's been sitting there. It relates to other aspects of the BRI, which we haven't touched on. Most of the time we've been talking about infrastructure, but the question, the questioner wants to know, how does the emergence of the health Silk Road, I guess in relation to the pandemic, along with the Green Silk Road and Digital Silk Road, present new opportunities for adjudication of disputes involving the BRI in the post-pandemic era? Justice Jones, would you like to address this?
Well, I think that's a very relevant but difficult question. The whole area of the environment and technology is at the leading edge of dispute resolution. Technology itself, of course, has contributed substantially to helping us continue during COVID with dispute resolution. But those issues, the issues of the export of technology and the protection of the environment, is something which I think will become a major part of issue resolution demands for the future. And insofar as they are part of BRI, it will be part of that process.
Thank you. And Justice Ramsey.
Yes, well, I was going to say that what one finds now in a lot of infrastructure projects is there are particular requirements as to green credentials and equally to technological developments. And those, I think, lead to types of dispute which are very familiar to those who deal with construction claims and infrastructure disputes. And I think, again, those novel questions which arise are something which really need to be dealt with by courts to set certain precedents.
Thank you. And I'm going to just break my own promise and sneak in a final question, only because it's related to the technology point that was just raised. And it comes again from Justice Wallbank from BVI. Does AI have any role in managing the volume of documents? If not, why? If yes, how? Really briefly. Just briefly. Justice Jones?
Well, I would say yes.
Sure. Go ahead.
I would say that AI does. I think one has noticed that the great thing about AI is it can recognize documents and pick up key documents. And therefore, I think that AI does have a part to play in it. But I fear that, as always, it will be the few documents which are key in every case, which take time to emerge in the process. And I'm not sure an artificial process will actually replace the normal human process in ascertaining those.
Okay, thank you. Justice Jones, any final thoughts on any of the points?
Well, I think the management of the data, the masses of data, is impossible without AI. But I agree that some actual human intelligent intervention is necessary at some point.
Thank you very much. And I guess with that, we've reached the end of our session time. Thank you very much, gentlemen, for your effort in preparation and in addressing this audience. We're really grateful to have your expertise shared with us, and of course to Mr. Wilken as well, who unfortunately isn't here to hear this, but I'm sure he will realize we're grateful. So thank you very much, and I'm sure we can take up some of these issues in a future forum. Thank you.